All right, let's be on the record in case number 2020-CR344, captioned State of Kansas versus Chauncey Wooden. Would the parties announce their appearances, please?
May it please the court, the state appears by Assistant District Attorney Taylor Hines via Zoom.
May it please the court, defendant appears by Zoom video in custody with counsel Anthony R. Russo, also by Zoom video.
All right. Mr. Wooden, as we talked about before we came on the record here today, and as the lawyers just mentioned, we're doing this by video conference. Given the pandemic, while it is possible to get in-person hearings, we'd like to save those for ones that are absolutely necessary. My understanding is you talked to Mr. Russo and you're fine with going forward with this by video conference today. Is that correct?
Yes, sir.
All right. And as we also talked about beforehand, to take up this plea, I need to ask you some questions. And for that, you need to be under oath. So if you would raise your right hand, please, Ms. Taylor will swear you in.
Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can go ahead and put your hand down, Mr. Wooden. All right, like I said, if I ask you something you don't understand, you need to let me know. Don't take a guess at what I'm trying to ask you, okay? Let's talk about it until we both are sure that we're on the same page. And like I told you before, if you want to talk to Mr. Russo in private at any time before answering a question, you just tell me and I'll send you to that special room so that you can do that, okay?
Okay.
How far did you go in school, Mr. Wooden?
I graduated high school and I got a little college under my belt.
All right. Sounds like you can read and write okay. Is that fair to say?
Yes, sir.
I know you're in custody, but as you're sitting here today, are you under the influence of any alcohol or drugs or prescription medicine that might keep you from understanding what we're doing today?
No, sir.
You feel like your mind is clear today?
Yes, sir.
Do you understand what you're charged with?
Yes, sir.
All right. You know that you don't have to change your plea from one of not guilty to guilty. If you wanted to maintain your not guilty plea, you would have an absolute right to a jury by trial in this case. Do you understand that?
Yes, sir.
At that trial, you would have the right to have a lawyer like Mr. Russo assist you. He would be able to cross-examine and confront all of the state's witnesses and testimony. He would be able to call any witnesses that you wanted called. And if they didn't want to come to court, he could use the subpoena power of the court to make them come. Do you understand all that?
Yes, sir.
At that trial, you would have a right to testify, but you would also have a right not to testify. And if you decided not to testify, that couldn't be used against you. In other words, Ms. Hines here couldn't get up and argue to the jury, well, ladies and gentlemen, Mr. Wooden must be guilty because he didn't tell you his side. Do you understand that?
Yes, sir.
If we went through that full trial, at the end of the trial, you were convicted, you would have a right to appeal that conviction to the appellate courts. If you didn't have money to do so, a lawyer would be appointed to do it for you. Do you understand that?
Yes, sir.
All right. Now, if I accept this plea today, you're going to be giving up all of those rights we just talked about. There's not going to be a trial by judge or jury of this case. You understand that?
Yes, sir.
All right. I'm going to share this document right now that's called the plea petition. And tell me if you can see this when I get it there. Can you see that document?
Yes.
Do you recognize it?
Yes.
Did you and Mr. Russo have an opportunity to go over this whole document before we came to court today?
Yes, sir.
All right. And I see at the bottom, there's a signature. I'll get to it. Right there. Is that your signature?
Yes, sir.
Mr. Russo, you signed it as well?
I did, Judge.
And Ms. Hines, I don't think you've had a chance to, but would you agree to acknowledge it and approve it today?
Yes, Your Honor. I emailed Mr. Russo one correction I have, and it's just a standard sentence to add to paragraph 13 to say that the state is not bound by the plea agreement if the defendant, excuse me, fails to appear for sentencing or commits any new crimes before sentencing.
Okay. All right. So do you have any questions about anything in this document, Mr. Wooden?
No, sir.
And you'd agree that it kind of goes over all of those rights that I just went over with you a few minutes ago?
Yes, sir.
All right. So in here, it talks about the plea agreement, and Ms. Hines just mentioned something that they normally type in there. It's not typed in, but they want to add it. It says that in this case, you'll be pleading guilty to count 2, which is the aggravated domestic battery, a level 7 person felony, and count 3, domestic battery, a B misdemeanor. The state's going to dismiss the rest of the case, the rest of the counts in there. The state will recommend the aggravated number in the appropriate box and recommend probation, and also that counts are to run concurrent. You are allowed to have contact with the victim, but it has to be nonviolent contact. And you have to successfully complete batterer's intervention within 4 months as a condition of his probation. Is that your understanding of the whole plea agreement, Mr. Wooden?
Yes, sir.
Now, the state said something that's usually typed in here, and it's really part of any of the plea, whether it's typed in or not. And that's that the state's not bound by their agreement if you fail to show up for court or commit a new crime while you're awaiting sentencing. Do you understand that?
Yes, sir.
Mr. Russo, with that addition, is that your understanding of the entire plea agreement?
Yes, Judge, it is.
Ms. Hines, same question?
Yes, Your Honor, it is.
Okay, all right. Now I see in there, Mr. Wooden, that there's a lot about what kind of sentences they're going to recommend to me, that I give you the aggravated number and probation, that I run them concurrent. You understand that while I'm going to listen really closely to what the lawyers recommend and what you have to say, that I'm not bound by any of those agreements, and I can give you any sentence that the law allows. Do you understand that?
Yes, sir.
All right. Now, specifically, I'm sure Mr. Russo went over what they believe your criminal history to be. Mr. Russo, what do you believe Mr. Wooden's criminal history to be?
I believe G.
All right. Ms. Hines, do you agree with that?
Yes, Your Honor, I do.
Yeah.
Okay. So here's the deal, Mr. Wooden. I assume that Mr. Russo went over your criminal history with you, where he expects you to fall in the box, and made a prediction of what your sentence is likely to be given that. What I have to do today is assume that you have the very worst criminal history possible so that I can advise you the maximum sentence that anybody could get for these crimes. Do you understand that?
Yes, sir.
All right. So the maximum that anybody could get for this would be 34 months imprisonment and a fine of $100,000, along with a post-release supervision of 12 months. Do you understand that?
Yes, sir.
All right. Mr. Russo has been your attorney for some time now. Are you satisfied with his advice and counsel?
Yes, I am.
Any complaints about the way the courts have treated you?
No, sir.
Okay. Before I ask you your plea, is there anything that you want to ask me about or that you're unsure of, either in this document or that you and I have talked about today?
No, sir.
Okay. Given that, as to count 2, the charge of aggravated domestic battery, which is a severity level 7 person felony, how do you plead? Guilty or not guilty?
Guilty.
As to count 3, the charge of domestic battery, a B misdemeanor, how do you plead? Guilty or not guilty?
Guilty.
All right. Now, Mr. Wooden, I'm going to ask Ms. Hines to tell me what she thinks the evidence would be if we went to trial today or in the future. I want you to listen closely because when she's done, I'm going to ask you if that's what happened, okay? Ms. Hines.
Yes, Your Honor. If this case were to go to prelim or to trial, the state would provide evidence that on April 18th of this year, around 8:30 p.m. at Kansas City, Kansas, police officers Ward was dispatched to 7350 State Avenue, apartment 619 in Kansas City, Wyandotte County, Kansas. And he interviewed the victim in this case, Alexis Dawn Rocha, and she told Officer Ward that she got into a verbal altercation with the defendant, Chauncey Wooden, in this case, that turned into a physical argument. The victim attempted to de-escalate the verbal argument and continue making dinner, but the defendant came up behind the victim, placed his hands around the victim, Alexis's neck, and threw her under the bed. He then placed his hands back on her neck and continued to squeeze and applied pressure on the throat neck area that impeded the victim's breathing more than once in this case during the physical altercation, where the victim began to pass out. The victim struck the defendant in self-defense in order to get him to pull away, and he did. The officer observed bruising around the left side of the victim's neck and what appeared to be petechiae surrounding the bruising as well. The defendant then left the victim's apartment and was later found at the Speedway gas station by other officers with the Kansas City, Kansas Police Department and taken into custody. The victim, Alexis Rocha, was in a dating relationship with the defendant at the time of this incident.
All right. Mr. Wooden, you heard what Ms. Hines had to say?
Yes,
Is that what happened in this case?
yes,
All right. I will find the defendant has freely, voluntarily, and intelligently waived his constitutional rights and entered his plea today. He's aware of the charges against him, the nature of and consequences of his plea, and he has entered into that freely and voluntarily. I will make a finding that there is a factual basis for this plea and find that the defendant is in fact guilty of count 2 and count 3. Per the plea agreement, the other counts are dismissed. I will order a pre-sentence investigation and set this for sentencing. If you give me 1 second, Miss St. James gave me a date for that. Let me see if it will work with everyone. Let's see. I am told August 7th at 9 a.m. Mr. Russo
Works for me so far.
and Ms. Hines.
Your Honor, I have another sentencing at 9 a.m. in Division 4 at that same time.
I can do 10 o'clock.
Your Honor, sorry to be difficult.
Okay.
I have a 10 o'clock in Division 16 at the same date. Sentencing.
Okay, let's keep going. 11,
I can do 11.
Mr. Russo.
I can do 11.
August 7th at 11 a.m. Mr. Russo, anything to be heard on the issue of bond?
Yes, Judge. My client has a current job offer that is open. He's not quite sure how much longer that will be available. He has been in since August. This should result in a probation situation so we can get him that batter's intervention treatment and things like that. I did explain to him why it was important that he return for sentencing and what could happen. And we've already talked about, the sentence that we've added into the plea agreement. That, of course, if he does not come back, not only does he lose the benefit of the bargain today, he would also open himself up to any new charges that may occur upon rearrest. And so the pressure's on my client to appear and do what he's supposed to do because this actually was a pretty good offer that the state made. So we are asking, he will be going back to that 7350 address, which is why we asked for the no violent contact with the victim, but he has a place to go and he knows to be back.
Ms. Hines.
Your Honor, I'd request that if he is released, he be monitored by pretrial services to ensure that he is here for a sentencing hearing. And of course, that's similar to what he would have to be doing on probation anyways. So I don't believe that'd be too much of a burden on him to start getting into that mindset of reporting.
All right. Mr. Wooden, you understand what everyone's saying here?
yes, sir.
Okay, the safe thing would be to sit there until sentencing. That way you knew that you wouldn't not show up for court or catch any kind of new charges or have a dust up with your girl again or anything like that. You understand that?
Yes.
So your take, and look, I'm going to let you out, but you understand that it's on you, that if you A, don't come back to court, or B, you and your lady get sideways again and the cops get called out, something like that, that could really make things bad for you. You understand that deal you're expecting to get for probation might not be there.
Yes, sir. I totally understand.
Okay, all right. So I'm gonna have pretrial come down and take a look at you, get you out. You are ordered to have no violent contact with the victim in this case, and to appear in court. Mr. Russo, can you get us a PSI request over to probation so they can be in touch with your client?
Yes, it should have been attached.
Is it in the end of the plea petition?
Yes, yes, it has been
Okay.
sent.
All right, I'll get it over to them. So probation's going to be in touch with you to get you set up to do a pre-sentence investigation. Okay, Mr. Wooden?
Yes, sir.
All right. Folks, anything else we need for our record today?
Judge, may I just have just a second with Mr. Wooden? Just to
You-
explain to him about pretrial.
Okay.
We can do it after the hearing.
Here's what we're going to do. I'm going to adjourn the hearing right now. We are adjourned. I'm going to stop the